Good morning, Rick.
Good
All right.
morning.
All right, I have resolved the technical issues, so we are
Okay.
ready to go.
We're ready to go then. All right. Well, good morning. We'll go ahead and call the October 27th, 2020 meeting of the Charlotte Zoning Board of Adjustment to order. We are now in session. I am Rick Sanderson, the chairperson. Also sitting on today's board is Terry Brown, the vice chair, Deborah Dryden, Patrick Welch, John Floyd, and Douglas Wilson. Also present are Shad Spencer, the zoning administrator, Lisa McCarter, the planning project manager, Therese Higler-Gray, Senior Assistant City Attorney, Thomas Power, Senior Assistant City Attorney, Max Oliver, Clerk to the Board, and Atkins, Court Reporting, Verbatim Reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic format. This is the 6th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today. As we proceed, there may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustments is a quasi-judicial body that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on requests for variance and appeals among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with newly enacted state statutes passed by the North Carolina General Assembly and Session Law 2020-3 that allows for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicants and the public in a number of ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property, and we notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can access today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This information was also included on the board's website. We will be hearing one type of case today, an application for a variance from the regulations in the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony pro or con must be sworn in. The zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for their case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than noon on Monday, October 26th, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board would not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk. The documents will then be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request as the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal, in accordance with North Carolina General Statute 160A-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will hear 4 cases today, 2 recommendation agenda items and 2 regular agenda items. The first case is case number 2020-091 for the property located at 3200 Auburn Avenue, presented by Lisa McCarter. Max, is there anybody for case 2020-091 who opposes that case?
No one has objected the case.
Okay. Let's see. I know John has a conflict on this case. So for case 2020-091, sitting on the board to hear this case will be Terry, Deborah, Patrick, and Douglas, as well as myself. Okay. Lisa and Shad, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Lisa?
I do.
I can't hear you.
I do.
You're very low volume. You're very soft. I heard it that time. Okay. So you can go ahead and start, Lisa, if we can hear you.
All right, can you hear this?
Yes.
Okay, case number 2020-091 is a residential rear yard variance. The applicant is requesting a variance to allow a 5-foot reduction in the 40-foot rear yard requirement in order to redevelop the property for a single-family home. And I'll give you a minute to look over your findings.
The findings were just sent to your all's email.
Okay, Lisa, you can start.
Government Exhibit 1 is a vicinity map of the subject property. Government Exhibit 2 is a zoning map of the property. The property is zoned R4 single family and is surrounded by other R4 single family properties. Government Exhibit number 3 is an aerial map of the property. The property is located in a residential neighborhood. Government Exhibit 4 is a close-up aerial of the property. You can see the property is located on a street corner, and the house is currently oriented towards the corner of the street. Exhibit number 5 is a background. The property was platted in 1952. You can see a star on the property there on the corner. The home was built in 1951, just prior to platting. Government Exhibit number 6 is the variance request. The existing home on the property predates any zoning ordinance requirements since it was built in the 50s. So the applicant would like to tear down the existing home and rebuild a new home. They're asking for a 5-foot variance from the required 40-foot rear yard for a 35-foot rear yard. The proposed elevation is shown on the right lower part of the screen. Staff does support the requested variance. There's a little bit difference in the application between what the applicant says the covenants require and what zoning requires. And I will note that staff believes that a hardship case can't be based on the covenants because they're shared by the other properties in the area and aren't peculiar to that particular property. And the city can't enforce the covenants. So they would be permitted to build within the zoning setbacks and yards. And they're outlined in red on the screen. So on the left side, there's a required 5-foot side yard. There's a required 30-foot front setback off of Auburn. On Greystone Road, there's a required 15-foot street side yard. And then at the rear of the property, there's 40-foot required. The applicant is requesting 35 feet. Due to neighboring property owner concerns, the applicant offers to impose the following conditions of approval: that the driveway on the property remain sited off of Greystone Road, that a French drain be provided that carries drainage to the curb and preserves existing vegetation between the property and the adjacent property, where that red car is there in the photo. And the neighbor has agreed to these conditions and supports the requested variance with these conditions. The considerations of the government exhibit number 8, the lot does predate the ordinance requirement. So when it was created, it didn't factor in that there would be a 40-foot rear yard and a 30-foot front yard to have to abide by. It's lesser depth than other lots in the area. Other lots in the area are about 140 feet deep. This one ranges between 82 to 100 feet deep. And here's a photo of the subject property. And that's my presentation if you have any questions.
Thank you, Lisa. Are there any questions for staff?
I have one question, Lisa. Are they reorienting the house, or are they going to leave it in this configuration where it, are they going to reorient it to face one of the streets as opposed to being this catty-cornered house?
Yes, they are. They're going to reorient it towards Auburn Avenue, and
Okay.
the side will face Greystone.
Okay, thank you.
Any other questions for staff? Is there anyone that wishes to speak in opposition or think that we need to move it to the regular agenda? Hearing none, is there a motion?
This is Terry Brown. I move to approve the variance.
This is Deborah Dryden, our second.
I have a motion by Mr. Brown to approve the variance, a second by Mrs. Dryden to Take a roll call vote. Mr. Brown,
Brown, yes.
Mrs. Dryden,
Yes.
Mr. Welch,
Yes.
Mr. Wilson,
Yes.
Sanderson, yes, so it's approved. So let's look at the findings of fact and conclusions of law.
Mr. Chair,
Yes, Mr. Powers.
just want to say, based on a legal review of the actual document, I do not offer any edits at this time for the board's consideration.
Okay, thank you. I didn't see anything in the findings of fact and conclusions of law that needed to be changed.
I didn't see anything either. Make a motion to approve the findings of fact and conclusion of law as written.
Dryden, second.
We have a motion by Mr. Brown to approve the findings of fact and conclusions of law as written. Second by Mrs. Dryden. We'll take a roll call vote. Mr. Brown,
Brown, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Welch,
Welch, yes.
Mr. Wilson,
Wilson, yes.
Sanderson, yes. So those are approved. Our next case on the recommendation agenda is case number 2020-098 for the property located at 429 Centerfield Drive.
Next variance request is,
Lisa, we can't hear you.
can you hear me now?
Yes, you're breaking up. Yeah.
Okay, the next request is a residential setback variance request. The applicant is requesting a variance to allow a 15-foot reduction to the required 20-foot setback in order to construct a new home on the property. And I'll give you a minute to look over your findings.
Thomas.
Yes, Mr. Chair.
It looks like this case and the next two cases on the regular agenda are similar. Do they need to be heard separately, or can they be heard? How do we need to do this, or just proceed as separate?
I will probably need from Lisa to know, are these all the same parcel with the same address?
No, they're separate parcels and separate addresses.
Okay. Given that, because this is not all related to the same parcel, I would actually ask that the board continue with each case individually. If there is some connection between them, then you may be able to look at some of the evidence in the next 2 or 3 cases, but I would ask that you evaluate each case individually because they're not the same parcel or address.
Okay. Thank you. All right, Lisa, then you can start.
All right, exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map of the property. The property is zoned R5 single family and is in an R5 single family subdivision with some I2 to the north, which is industrial. Government exhibit number 3 is an aerial map of the property. Government exhibit number 4 is a close-up aerial map of the property. The property is currently vacant. Exhibit number 5 is background of the property. The property was subdivided in 2000, and at the time of subdivision, the plat included a right-of-way that ran to the south of the property. You can see it's lot 6 with the red star on it on the graphic. And the railroad right-of-way was about 50 feet in the rear of the property. This left 59 to 98 feet of building depth at that time of platting. Exhibit number 6 is further background. After the time of the initial platting in 2000, Duke Energy acquired transmission line right-of-way over several of the properties on the north of Centerfield Drive in 2002, which included this property. This left a small portion of the property at the front along Centerfield to build, and the applicant was asking for a variance of 15 feet from the 20-foot setback to allow a 5-foot setback. But staff did not feel that was consistent with the rest of the neighborhood, which ranges in depth from 20 to 50 feet for established setbacks. So the applicant has agreed to a modified, reduced 5-foot variance request from the 20 feet to allow a 15-foot building setback. This would allow a 29.5 to a 50-foot building depth for the proposed property. Exhibit number 8 is the consideration that the 15 feet can stay within a certain range of the neighborhood characters and the established setback on Centerfield Drive, which ranges from 20 to 50 feet on the existing homes. Consideration on exhibit number 9 is driveway and sidewalk safety. Single-family residential zoning districts have a minimum setback of 20 feet to ensure that there's a driveway length of 20 feet for pedestrian safety, safe vehicle maneuvering area, and to ensure vehicles aren't parked on the sidewalks or in yards. And 15 feet is consistent enough to where they could be compliant with the 20-foot driveway if they located it to the side. Exhibit 10 is a photo of the property. You can see the property is vacant. So staff does support the modified request of 5 feet from the 20 foot. And that's all I have if you have any questions.
Okay, before we get to questions, let me state for the court reporter that hearing this case will be myself, Mr. Brown, Mrs. Dryden, Mr. Welch, and Mr. Wilson again. Also, Max, is there anyone signed up in opposition to this case?
No one has signed up in opposition to this case.
Okay, thank you. Are there any questions for staff? Does the board have any reason to move this case to the regular agenda? Hearing none, is there a motion?
I make a motion to accept the variance.
I second the motion. This is Douglas Wilson.
We have a motion by Mrs. Dryden to approve the variance and a second by Mr. Wilson. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Wilson,
Yes.
Mr. Welch,
Yes.
Mr. Brown,
Brown, yes.
Sanderson, yes. So it's approved. Let's look at the findings of fact and conclusions of law.
I don't see anything that we need to change, so I would vote to approve the finding of facts. Dryden?
Brown, I second that.
Okay, we have a motion by Mrs. Dryden to approve the findings of fact and conclusions of law as written. A second by Mr. Brown. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Brown,
Yes.
Mr. Welch,
Yes.
Mr. Wilson,
Yes.
Sanderson, yes. So those are approved. The next case, unless Mr. Powers, do you have any changes?
No, sir, I do not at this time.
All right, thank you. Our next case is 2020-092 for the property located at 421 Centerfield Drive. Now on the regular agenda items. So you can go ahead and start your, and on this case, we'll go ahead and have, since Mr. Wilson needs to leave at 10. Let's go ahead and have Mr. Floyd step in for Mr. Wilson on this case. So it'll be myself, Mr. Brown, Mrs. Dryden, Mr. Welch, and Mr. Floyd. Is that good, John?
Yeah, that's good.
Okay. Thank you, Douglas.
Thank you.
All right, Lisa.
All right, our next case is a resident setback variance. The applicant is requesting a variance to allow a 15-foot reduction to the required 20-foot setback in order to construct a new home on the property. And I'll give you a minute to look at your findings.
Mr. Chair,
Yes, Mr. Powers.
if I may ask Lisa McCarter a question.
Yes, sir.
Thank you. Lisa, just to clarify as a more procedural aspect, the applicant here, when they filed for these variances, they had one application that listed all three addresses on that one application, or was it three separate applications for the three separate parcels?
Initially, they submitted one application and we told them that they needed 3 separate applications for the different addresses.
So they did submit one application for 3 parcels, but then staff asked them to submit 3 different applications. Okay. The only reason I was asking that, I just want to clarify then, looking at the proposed findings of fact, in addition to ones that, you know, the board has already previously approved. And number 2, we have, you know, the applicant is Val Korvalenko, and it lists all 3 addresses for the application, even though we're only addressing one. So that's why I just want to ask that point of clarification.
So then we would need to make that revision during the review of the findings of fact.
And Lisa, that's why I was wanting to just double check with you, being that we're only addressing one parcel, which again, in this instance is 429, then.
This is 421, sorry.
Excuse me, 421, sorry, 421. Then I want to make sure then for number 1 and number 2, we only have just that information and not the other parcels. Is that correct? Or is that different than what staff is intending?
We did ask for
Hear you.
we did ask for 3 separate applications. I don't have those applications in front of me, so I'm not quite sure what is on those applications, quite honestly. I apologize for that.
Not a problem. I'll address. That's the information I needed, and I'll address that with the board when it comes time for their necessary vote and/or review of the actual findings. But thank you, Mr. Chair. I'm done with my questions, so I'll turn it back over to you.
All right, thank you, Mr. Powers. You can go ahead and proceed, Lisa.
All right, government exhibit number 1 is a vicinity map of the subject property. Government exhibit number 2 is a zoning map of the subject property. The property is zoned R5 single family, and it's located in proximity to the last location we just looked at. Exhibit number 3 is an aerial map of the subject property. And exhibit 4 is a close-up aerial map of the property. The property is currently vacant. Government exhibit number 5 is a background of the property. The property was platted in 2000 and is Lot 8 with the red star in the graphic. At the time of platting, the plat included railroad right-of-way to the south of the property, and that was approximately 50 feet. It left about 45 feet of building depth at that time. In 2002, Duke Energy purchased transmission line easement, and that easement covered most of the property and left about 33 to 32 and a half feet depth measured from the Centerfield Drive right-of-way. In which to build. And then you also had to accommodate for the 20-foot front setback, which would be subtracted from that area. The plat notes that construction was halted on neighboring lots 9 and 10 at the time of the plat recordation because the use of the property would be converted from single family to transmission line easement area. The hardship of the transmission line easement wasn't peculiar to the property because multiple lots on the north side of Centerfield were equally impacted by the acquisition of the easement. The variance request is for a 5-foot setback from the right-of-way of Centerfield in order to construct a home on the property. The R5 zoning setback is 20 feet. Staff does not support the requested variance. It's not in keeping with the character of the neighborhood because it would permit a 5-foot setback on the property. And other homes on Centerfield Drive have setbacks that range from 20 foot to 50 feet. The minimum setback for single-family zoning districts maintains a consistent streetscape with the community. Exhibit number 9 is a consideration of driveway and sidewalk safety. The variance isn't in keeping with the ordinance and doesn't uphold public safety because the ordinance requires driveways to be a maximum length of 20 feet for pedestrian safety, maneuvering, and ensure that vehicles are parked in sidewalks and yards. Exhibit number 10 is a photo of the subject property. You can see the property is vacant. And the applicant has indicated that they have a revised request after looking more into the lot depth, and they have a presentation as well. So that's it for my presentation if you have any questions.
So based upon this information, they could only build in a roughly 13 to 15 foot wide strip. Is that correct? With no approval of the variance? Lisa?
Yes, correct, because the property is in use for transmission line easements.
Okay. Are there any questions for staff from the board?
Mr. Chair.
Yes, Mr. Powers.
Lisa, just to verify, you indicated that the applicant has a modified request. Has staff it indicated, as staff had the opportunity to review and/or express an opinion about this modified request?
Staff received the request yesterday for a 14-foot reduction as opposed to 15-foot reduction. Staff does not support the proposed request. So we don't support the modified request. It's only an additional foot less.
Mr. Chair, I just wanted to ask that question for procedural reasons, just to make sure that the board is aware of both of the request and/or staff's position as you discuss and deliberate this, in addition to any information that the applicant or applicant's counsel provides in regards to both the first request and/or the modified request.
Okay, thank you, Mr. Powers. Before we get to the applicant's case, Mr. Murray, I have a question for you. Is your client planning to speak during your presentation?
Yes, sir. Val Kovalenko.
Okay, so I'll need to get him sworn in then. Okay, that's why I was asking the question.
And Mr. Chairman, I generally also swear in. I know that you don't have to swear in lawyers, but I always consider it that possibly that I'm also giving testimony.
Okay, they're very well then. So I'll swear both of you in then. Is there anybody else on your side going to?
Just me and Mr. Kovalenko.
Okay. Do you and Mr. Kovalenko, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do. Is Val on? He was on.
He is a panelist, so he should be able to mute and unmute himself, but I will go ahead and unmute him. Oops.
Okay.
Yeah.
Are you there, Mr. Kovalenko?
I'm here.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. Before you both start talking, when we get to your portion, please state your name and address for the court reporter. Are there any other questions from the board for staff before we get to the applicant's case? All right, hearing none, is there any questions from the applicant for staff before you get to your case?
I do not have any questions for Ms. McCarter at this time.
All right. Hearing none, then you can start your case, Mr. Murray.
Sure. Thank you, members of the board. My name is David Murray. I'm an attorney with the Odom firm in Charlotte. My address is 1109 Greenwood Cliff, Charlotte, North Carolina, 28204. I have the privilege today of representing the applicants in this hearing and the next one. And there was some conversations from Mr. Powers about potentially, or also Mr. Chairman Sanderson, about the similarity of these next two hearings. The presentation that I have prepared, although these are separate variances and I have separate applications in front of me, so there were separate applications filed for these variances. The presentation, I'm going to go through both of these parcels unless anybody has an objection. I just think it's easier to explain both of them at the same time. They're generally very similar in shape, size. The one that was just approved was obviously deeper, and so that's why there was a different consideration made there.
All right, Mr. Murray, just a second.
Yeah.
Mr. Powers, would that be acceptable? Or do we need to hear it separately?
Mr. Chair, my recommendation would be to allow Mr. Murray to go ahead and present his presentation for this application as well as the next one. I think when we go into the second application, which is, as Mr. Murray indicated, a companion application, I think it would be prudent at that time to at least have Mr. Murray to then reiterate quickly that he has given the prior testimony and that he would like that testimony for this second application to be incorporated into that application at that time. Similarly, if the board goes down the path of trying to address maybe the second application, I can kind of help to police that to ensure that we're addressing it fully at that time. but I do not see a problem ultimately with Mr. Murray providing testimony for this application and the second one, so long as we acknowledge and have Mr. Murray to actually reiterate that all the testimony would then need to be reincorporated to the second application.
And that would suffice for the court reporter to make sure that the court reporter has everything documented for both cases.
Because I cannot see the court reporter's name on here, I would say that should suffice in that regard. If this becomes a situation where, let's say, the board either votes both to approve or both to deny, it would be a very clean record for Mr. Murray to kind of deal with if he needs to appeal. It becomes a different situation if one was to be approved and one was to be denied. Then it becomes a little different situation. But that's why I've indicated if Mr. Murray is going to present for both applications now, if we go to the second application, then he would need to reiterate that in the second application, he is reincorporating previous testimony that was already given as sworn testimony to this application. The only other advice I would recommend in this instance, and I believe Mr. Murray would probably have already done this, is to ensure that his testimony related to the parcels is segmented out to make it clear that you're referencing, the current application, and then when you transition to the second one as part of your presentation, that you're referencing that second one as a distinction for purposes of the record.
Okay. Thank you, Mr. Flowers. Go ahead and proceed, Mr. Murray.
Thank you. Lisa, can you advance the slide, please? As the applications show, this is a request on 2 adjacent properties. We will show the plat here in a minute. But we did make, just so the board is aware, we worked hard over the weekend to see if there was any way possible that we could squeeze more to push a possible house as far back from the front yard property line as possible. And so on 20092, we were able to squeeze 1 more foot. And on 20097, we were able to squeeze 2 more feet. So the request that we are making today would be a 6-foot setback on 20-092 and a 7-foot setback on 20-097. At this time, I'd like to have Mr. Kovalenko introduce himself to the board and tell the board what what he does and what his company is why they're looking at getting the variance for this property.
Okay, Mr. Kovalenko, please state your name and full address for the court reporter before you begin your presentation.
My name is Val Kovalenko. The address is 5011 Riverdale Drive, Charlotte, North Carolina, 28273. And I'm a builder, a local builder here, that we are constructing affordable housing in the area throughout northeast and southeast of Charlotte. This year alone, we're going to be closing in over 20 homes that we already will have finished up. And the main purpose of the business is to provide affordable living, which is in need right now. The houses square footage that we build range anywhere from 12 to 1,800 square feet. We have a lot of them at about that 1,200 square feet range. These lots here would be a perfect spot for us to build a housing, the type of housing that would provide affordable living for people that are really looking for people are really lacking at this time. So this house here is a 2-story, 3-bedroom, 2-bathroom. Would have a parking on the side, which would have on the lot 8 would have roughly about 22 feet in width and also about 24 to 25 feet in depth. And then on lot 7, similarly, would have it about 20 feet in width and about the same in the depth. So this would perfectly fit into a portfolio that we're doing, and I think it'd just be a great idea to provide more affordable living to the people that's really looking for that type.
Mr. Kovalenko, have you reviewed this PowerPoint, and is what's contained in this PowerPoint true and accurate to your knowledge and represents your testimony?
Yes, I did review it, and it does represent exactly what I'm testifying.
And you did just confirm that a driveway depth of 20 feet can be achieved on this property.
That's correct.
Lisa, can you move forward, please? Members of the board, this is a revised plan showing that what we've changed on lot 7 and lot 8. And again, lot 8 is variance 092 and lot 7 is variance 097. If you remember, the 097 corresponds with the lot 7. That's an easy way to remember it. Looking at lot 8 first, as you can see here, there's a Duke Energy easement on the back of this property that the previous landowner and the current landowner did not cause to happen. Duke Energy acquired this under a threat of condemnation. It was a acquisition under eminent domain power. And what it did was it left a situation where there was no ability for anyone to construct a house on these properties. And so what we have done is we have taken a plan that Mr. Kovalenko has put together, and we have shown a size house that is in conformity with this neighborhood on these properties. But we cannot put the house all the way up against the Duke Energy easement. So you will see that on lot 8, there's a 1-foot buffer, and on lot 7, there's a 1.2-foot buffer. And that's because we just do not want to construct houses immediately on the power line easement. And so you can actually see on this plan, the overhead utility lines are a good ways back behind this property. I mean, right behind where this house would be located. It's approximately where the hatched line is on the plan. And the overhead utility easements would be over approximately 25 to 30 feet away from the rear of these houses. As you can see from the front of these houses on lot 8, we were able to push the house back to get a 6-foot front setback. And on lot 7, we were able to push the house back to get a 7-foot front setback. Lisa, can you advance the slide, please? Obviously, we're here for a variance, and I always like when I'm presenting for a variance to review the variance standards, just because I think sometimes it's important to go through exactly what has to be done here in order to obtain a variance. And these were revised in 2013, and it was important when they were revised in 2013 because the language changed. And the language that was added to the variance standard was that the board shall vary any portions of the zoning ordinance upon a showing of all of the following. And the first is an unnecessary hardship. The second is that the hardship is based upon conditions peculiar to the property. The third is the hardship did not result from actions taken by the applicant or the property owner. And finally, that the variance is consistent with the spirit and intent of the zoning ordinance such that public safety is secured and substantial justice is achieved. The last phrase is what's most important about the last section, is that for subsection 4. So the board shall vary upon a showing. So our job is we just have to make a showing of evidence on each of these elements in order to obtain a variance. Lisa, can you please advance? On the first element, on unnecessary hardship, we're talking again, both of these parcels, lot 7 and lot 8, is that without a variance, a setback variance, a single family residential structure that would conform with that neighborhood cannot be built on the property. There's not enough space. There's approximately 13 feet. That would not allow a single family residential structure of any quality to be built on this property. When the lots were originally platted in 2000, the intent of the approved subdivision plat was for single family residences to be constructed. And in fact, when you look at the Duke Energy plat that was provided as an exhibit by the city, you can actually see that they were planning and had concrete foundations ready to go on these properties in order to construct to provide housing in that area. Obviously, that didn't happen because in 2002, Duke Power took an easement across the parcels, causing them to be unbuildable without a front setback variance. The city has said that the use of that property is for a power line, but I don't think anyone would agree that the use of property for a power line is the highest and best use of the property. The highest and best use of this property is for single family residential. It's zoned R5. It's in a neighborhood at the end of a cul-de-sac. And so the highest and best use here would be for single family residential. Lisa, can you please advance? The second element is that the hardship must run with the land. It must be connected to the land. It must be as a result of what's happening on the land. Here, the hardship is not personal to the applicant or any applicant that comes before you. So whether it's my clients or anyone in the future, this is not a personal hardship. This is a hardship connected to the land. It's directly related to the placement of a Duke Power easement across the lots under the power of eminent domain. And I always compare situations like this. This is in the rear of the property, but it's very comparable to a situation where if a highway project had come through, taking frontage, and when you go to construct the property, now your setback is farther. And so if you're going to rebuild the house, you have to build it in a different location, and you may need a front setback variance because the road has been widened in front of your property. And so there's a change that occurred to this property in 2002. And what the change was is that there was a power line easement that prohibited any construction within that easement on the property. I also disagree with the city that this setback issue is not peculiar to this property. If you look at an aerial picture that the city provided, there are only a couple lots on this street where this issue has come up as a result of the power line being placed on the back of this property. And it has to be common in the neighborhood. The standard, it would be that it would be common in the neighborhood. This neighborhood, as you can see in the aerials, has hundreds of houses. It is not common in the neighborhood. There are only approximately 5 to 6 lots that are affected by this. And one of those was one that was just approved in a variance, albeit a less setback, but that property has much more depth than these properties. And so it was easier to revise the plan to be able to provide 15 feet where that's not possible on these properties. Lisa, can you please advance? The third standard is whether it is a self-created hardship. And here, the evidence shows that it is not a self-created hardship. The applicant or any applicant did not create the hardship on this property. This applicant was not the owner of the lots at the time the Duke Power easement was acquired on those lots, but even if they were, they did not cause this. The government and utility companies has the power of eminent domain just as they do with zoning powers. And that's what's caused the hardship here. So it was not self-created. Next slide, please. With regard to the last element, because that seems to be where the most disagreement has come up, at least from my review of what the city has presented, is about the intent and then the conformity with the neighborhood and public safety, substantial justice. This is really a balance. And when you look at these issues, that's why when I went through the variance standards, I pointed out that the variance is consistent with the spirit and intent of the ordinance, such that public safety is secured and substantial justice is achieved. And so with substantial justice, you're looking at the property and the property owner to determine, does this make sense to allow this variance in order to allow development of these properties? And so when you look at the intent of the zoning ordinance is intended to provide organized development within the city. I think everybody agrees with that. The second step is the intent of the setback rules is to ensure that the front faces of structures along a street have uniformity. They're not so close to the street as to create a hazard. As we've already heard from Mr. Kovalenko, who testified earlier, the city's concern was about being able to get a driveway that was 20 feet deep. And if you look, Lisa, would you be able to go back to the slides where I had the plat? I think it was like my second. Thank you. When you look at these plans on lot 7 and lot 8, you will notice that the houses are pushed as far over to the right side as possible. That would be the east. As far over to the east as possible because there's a side yard on these properties. And on the left side, the west side, Mr. Kovalenko testified earlier that a driveway would be able to be constructed on this property, not in the right of way, not where the sidewalk is, but a driveway constructed on this property that would allow a depth of 20 feet and would actually be able to exceed 20 feet. And so the concern about the driveway not being 20 feet is not a concern because our architect, Mr. Kovalenko, is the builder here. He has confirmed that a 20-foot driveway can be shown on this property. The only difference in what these properties will show and what the other properties that are already constructed out there is there's not enough space to put a single car garage. Some of the houses have single car garages. This does not. But if you notice in the aerial pictures that were provided in this area, most of the people are parking on their driveways. So it would not be unusual for people to be parking on a driveway in this neighborhood as the pictures will show. Lisa, if you could go back to the secured public safety. Thank you. It's also important to point out when we're looking at these properties that there is in fact a sidewalk existing on these properties. It's actually in the city's right of way, so it's not an easement on the property. It's in the city's right of way. And the sidewalk actually creates a bit of a buffer between the actual road and the actual street. We did a measure, Mr. Kovalenko and I did a measure on the two lots, and on lot 7, there was actually a distance of approximately 17 feet. And on lot 8, there was a distance of approximately 16 feet from the proposed stoop of the house to the actual edge of pavement. And so from the road, the actual edge of the road, these houses will be set back approximately 16 to 17 feet. And that's from the stoop, which sticks out 2 feet off the front of this house. So the front of the proposed house would actually be 2 feet further back from that. And so that's important to point out that just because this would be a 6 or a 7 foot front setback, it doesn't mean that the street is right at that 6 or 7 foot line. It's actually not. It's more like 16 and 17 feet. And it's also important to point out, as shown on the aerials and the plat, that these lots are located on a residential street that's a cul-de-sac. And so you're going to have low traffic volume and a low speed limit on these streets. So it's not like we're seeking a 6 foot setback or 7 foot setback on Providence Road in sections where there's no sidewalk, where there's tons of traffic and a lot of vehicles passing. This is a cul-de-sac residential neighborhood where these houses would be located. When we look at the substantial justice portion of the equation, first of all, the Duke Energy plat shows that there were houses intended to be built on these properties. And if the variances are denied, there's not going to be any houses built on these two properties. And so effectively, without this variance, and this board has said before that they are the last resort, without this variance, there will be nothing built on these properties. And if you look at if you see the aerials and that have been presented and the pictures of the lots are currently overgrown. They're used as yard waste dumping grounds, basically, because there's nothing there. The sidewalks have been neglected and are often covered with silt. In fact, at first, when I saw them, it was a little bit hard to even see the sidewalk, but yes, they do exist. Some pressure washing would do them good. And so right now, the lots are not in use and are really a negative for the area, given that they're overgrown and the way that they're currently being used. If you could move forward, please, Lisa. There was also a discussion about conformity with the neighborhood. And the plan by the applicant seeks to be in conformity with the neighborhood in order to allow development on the north side of the street that's affected by this power line. When in seeking the variance for 429 Centerfield, which was the variance that was just approved, the consideration that I had and the consideration that the city also had was, if we are looking for a smaller setback on lots 7 and 8, then it would make sense to have a transition on lot 6, which is the lot that the variance was just approved on, to have a transition between the existing corner house, the 2-story house that's shown on the right side of the plan that you see on this PowerPoint, to have a bit of a transition of a setback to these houses, so that it's not just all of a sudden there's a 20-foot setback and then there's a 6-foot setback. And so there's a bend in the road that creates a bit of a natural change in this area anyway. And so with the variance that's been approved on lot 429 or lot 6 with a 15-foot front setback, that'll provide a transition between the existing house that has the platted setback, then that house, to a transition to these houses. And so this is a sketch that I provided. I provided this to the city when I got involved. But basically what it's showing is we know that if a variance is granted, there's enough space to build houses that conform with this neighborhood. But without those variances, nothing can be built. And so that is ultimately goes back to the substantial justice, and the intent of the ordinance is allowing development, organized development. But what I've pointed out here is this issue is not common in the neighborhood. It's only related to these lots. It was not created by the subdivision plat. This is not a grandfathering issue, but this is an issue where in this neighborhood of all these houses, these lots were negatively affected. And because of the negative effect, there's further negative effect of the fact that there are no houses there, and those lots are just going to sit and linger and stew, and nothing positive is going to come out. And so So that's why I prepared this. The red line is showing approximate. It's not exact where the setback line is, but what it's showing is that a transition can be achieved here using the previous variance and using the variances we're asking for to allow some conformity. I use the comparison here to the alternative minimum setback, which sometimes is used in older neighborhoods where the houses are built right up on the street. They're torn down, a new house would be built, but the new house would have to comply with the setback standards. And the city acknowledges in the zoning ordinance, I think it's footnote 9 to 12.106, I believe is possibly the section. But I compare this to a similar situation to that, where the intent of the alternative setback is to try to line up houses so that they match. And these variances here, if they're granted, you can see the property on the other side has a similar issue. And so it's not like there's going to be a zigzag of houses on that side of the street. The houses would be in conformity with each other on that side of the street, albeit there would be a reduced setback. But the point of the zoning ordinance in allowing a variance in the first place is that if there is a setback reduction, then obviously the setbacks on the properties that have a granted variance would be less than what is happening in the rest of the neighborhood. So I heard the city say that they did not believe that this was in conformity with the neighborhood because the setback was less than 20 feet, but we can't achieve that here. And the neighborhood would be in conformity if we were able to build houses that were actually built on these lots that were intended for single family. Lisa, can you please move forward? This exhibit is showing the existing houses that are located. And to orient the board, 433 Centerfield is the house that's on the same side of the street, but it's adjacent to the house or the lot that you just granted the variance on. And so it is a two-story house with a single car garage. And the depth of that structure is 26 feet deep. And I mean from the front, the overhang or the stoop on that house to the rear of it is 26 feet deep. The house at 428 Centerfield is directly across the street. And the house at 418 Centerfield is also directly across the street from the two lots that we're talking about here. 428 Centerfield is 25 feet deep, the depth of the house, and 418 Centerfield is 26. And so what we were looking at, and Mr. Kovalenko was looking at, was if we're going to construct a house that's in conformity, we need to know what's directly across the street and what's next to the variance that was approved. Can you advance the slide, please? And so what the proposed house plan that Mr. Kovalenko designed is a house showing 25.5 feet deep. Now, keep in mind the 2 feet on the front of this house is for the front stoop, because these houses that are in this neighborhood have covered front entranceways. Some of them have more of a porch front, and some of them just have the overhang over the front door. And so 2 feet of this is for that. And so the house structure itself is really more like 23.5 feet deep. But then you include the front stoop, which adds an additional 2 feet. If you could advance the slide, please. The proposed house plan, I think it was shown in the previous variance. But because the houses are built up front, the lots are narrower. And so this is the general design of the house that would be built in order to maximize as much possible space so that it is a desirable house for someone looking for affordable housing, but also that it is conforming with generally what is in the neighborhood. And this is the proposal for the house. As you can see, it has the front stoop on it, and it's kind of the general similar design to what's already in the neighborhood. And again, this is 25.5 feet deep. For the most part, I believe that is our presentation. I would ask Mr. Kovalenko just to confirm that the statements that I have made, the representations of his testimony are accurate, and that he would adopt my statements as his testimony.
That's correct.
Members of the board, again, I believe that we have made a showing here on both of these, and I can reiterate it for the next hearing, but we have made a showing here on this case sufficient to grant this variance, to grant a variance in order to allow houses to be constructed. Sorry, I'm pulling my notes up here. I want to make sure I'm getting the right numbers for you. That for the 092 case, again, it would be a 6-foot front setback that we're requesting. And for the 097 case, it would be a 7-foot front setback. And if members of the board have any questions for me or Mr. Kovalenko, we would be happy to answer those questions.
Thank you, Mr. Murray. Are there any questions from the board for Mr. Murray or Mr. Kovalenko?
I have a question. I know you said that you could put a 20-foot side driveway. How wide would that driveway be? For this
on lot 8, it will be about 22 feet wide. On lot 7, it'll be around 20 feet wide.
And what does that do to the actual yard space for the home? I mean, I'm looking at this and I understand that you want to put the house there. You put the house in the driveway. What open land then does it leave for the homeowner to have for yard space?
They can have they have a little bit of the front yard. They have a backyard, which is there. You cannot use it to build or to construct anything on the backyard, but they still have a decent sized backyard they could use if they want to walk their dog, or I believe it could be used for purposes of just if they have kids, play soccer or play games. I don't believe that's going to be an issue there because it's a really good sized backyard.
That is correct. There's no restriction on using. There's only restriction on building for the backyard.
So could they put a swing set back there?
I think they would have to talk with Duke Energy. There's different kind of approvals. Generally, Duke Energy just requires a review and a written approval. I cannot represent what Duke Energy is going to do. I've had clients in the past that have gotten written approvals for things that Duke Energy would not consider to be an impact on their power lines.
Okay, thank you.
Any other questions for the applicant?
I've got one. This is Terry Brown. I'm assuming that, these homes being built there, what type of foliage will be in the back of that yard, and how will that be impacted by the power lines?
The Duke Energy really kind of governs what would actually be back there. There's no restriction on having shrubs. There's no restriction on having gardens. There's no restriction on, whatever standard type things happen in backyards. The only restriction would be is if there's any what they call danger trees or risk trees, meaning trees that could somehow affect the power lines. And so Duke Energy, I believe, has already come in and taken out what they would consider those trees. But there's no restriction on shrubs and things like that that they can put in the backyard, gardens, all that can be done. They can farm it if they want. I mean, I don't know that they would, but all those type of close to the ground things are what's generally done. And I will say, I mean, generally there are a fairly large amount of neighborhoods that are built adjacent to power line easements. And so there are those restrictions, obviously, but it varies. I mean, there's easements that go through different neighborhoods. There's a massive one that goes through Valentine Country Club, just to give an example. So it's from all varying levels of housing types. And it's just, the one thing about here is the backyard, they can't put a house in it, but it's still theirs. So Duke Energy has a right to put a power line in it, but the owner that buys this lot still owns the lot. So it'd still be their ground.
Any other questions for the applicant? All right. Are there Max, did anybody sign up to speak in opposition or for this case?
No one has signed up to speak in opposition or for the case.
Okay. Hearing none, is there any final comments from city staff?
No final comments.
Okay, thank you, Lisa. You have the final word, Mr. Murray. Anything else you want to tell the board before we close the hearing?
No, I just appreciate your time and consideration and hope that you will move to approve these variances. Thank you.
All right. Thank you, Mr. Murray. I'll go ahead and close the hearing then. We'll go ahead and start our deliberations. Who wants to start? Mrs. Dryden, you want to start since you're the first person I see on my screen?
I can see the dilemma of this property. I know in neighborhoods it's terrible to have lots that are not kept up and that are dumping grounds for things. I'm just concerned about, I know we want to provide good quality homes at affordable prices, but to plop a house down on this very narrow lot, even though they have access to the property that is the Duke Power easement, they can't really put structures back there. I'm so torn. I'd like to say yes, but then I'm worried about how close it is to the street. And I mean, I looked at his graphics, and even the easements on the sides of the lot 9 and the lot 5 are farther back. I don't know. I need some guidance. I need some other opinions because I'm really torn about this particular easement.
Mr. Chair.
Yes, Mr. Powers.
I do want to highlight one quick point for the board itself. I do not recommend that the board consider or even factor as part of your deliberations about this property being used for or at a price point that is considered affordable housing. That is not a matter that's related to the zoning, which is the use of the actual property. At this time, I would definitely emphasize that while that information has come out as part of their presentation and their reasoning, as you are evaluating whether or not to grant a variance, the affordable housing aspect is not something that is going to be part of or a consideration for the actual variance to the zoning ordinance. I also do want to say in this regard that as you are evaluating the actual request, you can take into consideration, again, the information that was presented for this particular type of application in regards to the current restrictions from Duke Energy. But I do want to highlight and emphasize that you do not want to go down the path of being too speculative or leading to hypothetical situations as to what could happen in the future. The only thing that you can take into account is what is going on with the property at this moment as you're evaluating that. So I do want to kind of give you those kind of mile markers as you're kind of walking on the path of evaluating this project. Thank you, Mr. Chair.
Thank you, Mr. Powers. Hey, Mr. Brown.
I would start by saying that I understand Ms. Dryden's concerns about the size of the lot. I don't have the same amount of concern. I don't have as much concerns about the space of the closeness to the street, but I also guess I struggle with the fact of the use of the property. And I think that if we're looking at the argument that Mr. Murray made about the highest and best use of the property, when you've got a narrow lot like this, I tend to think that the highest and best use would be able to use it for housing instead of letting it sit. I've driven around other parts of the city where we've got lots, and some of those lots, there's a lot near my home that's got a power line easement on it, and it's a blank, empty lot, and it's been like that for a long, long time, and there's nothing going on with it. So if we are able to find creative ways that are within the scope of the zoning code to use these types of property, I think that does our city a benefit. So I'm inclined at this point to grant the variance, but I'm willing to hear what everybody else has to say as well.
All right, thank you. Mr. Welch.
All right, good morning. Look, I know the intent, for me, the intent is good to provide housing on a otherwise dead lot. I understand that. However, as Ms. Wright said, just to plop the house on any lot, it concerns me. My concern again is the use of that lot. And right now, the closeness of that lot to the street is definitely a concern for me. So at this point, I'm inclined not to approve the variance. But again, those are my thoughts right now.
All right, thank you, Mr. Floyd.
I will say that when this hearing started, my initial reaction was to be against this, but I think Mr. Murray did a very good job of laying out how, if you look at the factors that we're supposed to consider, that this is the type of variance that we can grant. I do think, without this variance, it seems unlikely to me that this lot will ever be anything other than a vacant lot. And I agree with Mr. Brown that if we've got an opportunity to actually make some positive use out of it, I don't know why we wouldn't do that, absent some compelling justification as to, a lack of safety or something that raises those kinds of concerns. The homeowners the property owners testified that they would be able to include the 20-foot driveway. Not being able to build at all would seem to me to be an unnecessary hardship. That is resulting from this easement that was taken by Power, not by anything that the owner did. And I will say, when you looked at the exhibit that was put on that showed how the front of the property would compare to its neighbors, none of the homes in this neighborhood appear to have large front yards, and it did look like these homes could be set on these properties in a way that would look consistent through the neighborhood. Given all that, I would support the variance.
All right. Thank you, Mr. Floyd. My opinions are that I think that the hardship obviously is wasn't created by the property owner. It was created by the Duke Energy easement that was taken through eminent domain. Yes, the house will be small, the lot be closer to the street, but if they do it right, I don't think it'll be that bad, that obvious. I'm inclined to approve the variance. I think that it's the best use of the property, and I think that as Mr. Murray laid out this board's requirements, I think that this property meets those hardship requirements that we were supposed to evaluate. So I'm leaning towards approving it. Any other, have any more deliberations amongst the board?
This is Ms. Dryden. I like everything that everyone has said. I just want to be sure that we are making sure that the developer sticks with this revised easement request, because that's not what is in our finding of fact. So we'll, that they're not asking for a 15-foot, but a 14-foot, and then the other one was well, we'll get to the other piece of property, but to make sure that the setback is as far back as they can get it, and that we do have the 20-foot driveway, and it's 22 feet wide, so that it does fit a car or an SUV.
Yeah, I don't know necessarily if we can make
Well,
that.
no, you can't require, but I mean,
Yeah, make that statement. But we definitely, when we if there is a motion made for approval of the variance, then the motion would need to include that it's an approval of a 14-foot reduction for this
right.
case 092.
Right. Okay.
And so,
Then,
I mean, that would have to be in the motion.
Correct. Well, then, with that, then I make a motion that we approve this variance, because we do need to use, I mean, I agree with you. There's not much else that you can do with this lot. And really a smaller house footprint wouldn't necessarily, I mean, fewer bedrooms wouldn't change the actual pad that the house sits on. So with all the things said, I would vote to approve.
This is Brown. I second that
motion. All right, so we have a motion by Mrs. Dryden to approve. Sorry, I have a dog here that now decided to bark. We have a motion to approve a 14-foot reduction of the setback by Mrs. Dryden, and a second by Mr. Brown. We'll take a roll call vote. Mrs. Dryden?
Yes.
Mr. Brown?
yes.
Mr. Welch?
No.
Mr. Floyd?
Yes.
Sanderson, yes. So it's approved 4-1. Okay, let's look at the findings of fact and conclusions of law. Obviously, we will need to change the conclusions of law to correspond to the approval of the variance. And we need to change number 1 on the findings of fact and take out the 425 and 429.
Mr. Chair,
Yes, Mr.
I have
Powers.
proposed language that if this board were to approve it, we can apply this for not only this application, but also the previous application and the future application that we'll consider. The revised language would actually read, the applicant is Val Kovalenko, comma, and has submitted applications for 421, 425, 429 Centerfield Land Trust.
I would like to just point out that that is the name of the property owner. 421, 425, 429 Centerfield Land Trust, LLC.
Ah,
I guess we just need to put LLC at the end of that trust.
And yes, that would be more appropriate then.
Okay. And then number 2 would take care of the actual address of this property.
Yes, sir.
Okay. What other changes do you have, Mr. Powers? Recommended changes?
I do not have any other changes other than the LLC and also addressing the reduction from 15 to 14 as you've indicated beforehand. And I think we'll need to change the conclusions of law to address the hardships being a result of the strict application. It would just be the inverse of what is currently there. That would account for that very issue.
Yes. Okay. Are there any other recommended changes from the board? Hearing none, is there a motion from the board?
This is Terry Brown. Motion to approve the findings of fact and conclusion of law as amended.
This is Deborah Dryden. I second.
We have a motion by Mr. Brown, a second by Mrs. Dryden to approve the findings of fact and conclusions of law as amended. We'll take a roll call vote. Mr. Brown?
Brown, yes.
Mrs. Dryden?
Dryden, yes.
Mr. Welch?
West, yes.
Mr. Floyd?
Yes.
Sanderson, yes. Okay, those were approved. The next case is 2020-097. Mr. Powers, how should we proceed with this case, since it seems like we just heard this case, the presentation for this case?
Mr. Chair, it depends on how staff wishes to proceed. I do believe staff did not present their presentation on this one, so I think staff does have the ability and need to present their case in this instance. In regards to Mr. Murray, since he has already presented information previously related to this parcel in a previous case, I think we can actually allow Mr. Murray to just say, I wish to incorporate my testimony from the previous case and list that case number into this case related to this parcel, and at which point he can then, field any questions of the board at this time, or at that time, excuse me.
Okay. Mr. Welch, do you have to leave at 11, or we have 17 minutes to get to 11 o'clock. So do you have a hard time to leave at 11?
It's not a hard time. I can stay.
Okay, thank you. All right. Lisa, let's go ahead and start the presentation for case 2020-097 for the property located at 425 Centerfield Drive.
Okay. It is substantially similar, so I will just go through very quickly. It's a residential setback variance to allow a 15-foot reduction to the required 20-foot setback to construct a home on the property. Exhibit 1 is the vicinity map. Exhibit 2 is the zoning map. The zoning is R5, single family. Exhibit 3 is an aerial map of the property. Exhibit 4 is a close-up aerial map of the property. The property is currently vacant. Exhibit 5 is background of the property. It was platted. It had 45 feet of building depth at that time. Duke Energy acquired additional property. And now the applicant is asking for a 15-foot reduction from the required 20-foot to allow a 5-foot setback. A consideration is that it's not in character with the neighboring established setbacks, and also the driveway and sidewalk safety. And I will say that one of the findings is that the hardship is peculiar to the property. The hardship is shared by many properties along the north side of Centerfield Drive, so it is not peculiar to the property. So staff does not support the requested variance. And that's all I have if you have any questions.
All right, I guess let the record show that Mr. Murray, I guess he'll state it again, but he's, on this case, now has revised the request for a reduction of a 13-foot reduction in the setback versus a 15-foot reduction. So are there any questions for staff? Okay, hearing none. Mr. Murray, you can present whatever you want to on this case.
Thank you, members of the board. Just confirming again, This is a 13-foot reduction that would provide a 7-foot front setback. I would incorporate my testimony, exhibits, and presentation, as well as Mr. Kovalenko's presentation. And I would point out, though, that the housing plan that was shown by the city is not correct. The housing plan that we showed in our exhibit is what we're planning, that has the 2-foot stoop on the front to match the design in the neighborhood. And so nothing additional here. We would support your approval of this variance. The one that was just approved was a 6-foot setback. This one's a 7. The one that was approved earlier is 15. Again, there's a transition. So I appreciate your consideration, and if there's any questions, I'll be happy to answer.
All right, thank you, Mr. Murray. Are there any questions for the applicant from the board?
I do have a question. Mr. Murray, when Mr. Kovalenko purchased the property, was he aware of the Duke Energy easement?
Yeah, it's on the plat, but going back to the standards, if you purchase the property with knowledge that a variance might be needed, that, is not something that can be factored in against him. So he did know, he does know about it. It's on the plan, but that's why they're seeking this variance, is because they were hoping to be able to use the property.
All right, thank you.
Any other questions for the applicant from the board? Does staff have any questions for the applicant?
Mr. Chair.
I just want to make sure that the driveway and for this piece of property is the same as the last. It's going to be 20 feet deep and at least 22 feet wide.
On this one here, it will be as deep as the other one. The width of it might be 20 feet wide instead of 22, just because this lot sits a little bit at the angle. The house will be pushed all the way back to the east side. So we'll do whichever is maximum. It will be a minimum of 20 feet. It might be a little bit more.
Does anybody know what's the normal size of a driveway? I don't really know.
A normal two parking spaces is 18 feet.
Okay, thank you, Mr. Corwin.
Mr. Powers?
Mr. Chair, if I may have a moment of just clarification with staff on a procedural matter.
Yes, sir.
Lisa, just to make sure I'm reading this properly, related to, go to the right one, hold on a second. Yes, for 2020 97, which has the right one, yes, 2020 number 97, number 17, it says granting the request will permit a 5-foot setback on the property. Just to make sure for the board, if they were to grant the variance, that information does not need to change, correct?
We would be doing a 7-foot setback.
Okay, that's what I was asking that question, because I want to make sure it's all aligning because we have a modified request.
That's right. Yeah, this one's modified to 7 feet.
Okay, that's what I just wanted to verify. Thank you.
And then the previous one should have been modified to 6. If we didn't make that, do we need to go back and revisit that, or can we just make that in the edits?
I would first, let's just go ahead and address this one, and then I can address that issue with the board.
Okay, thank you. So it'll be okay. Max, is there anybody signed up to speak for or against this case?
No one has signed up to speak for or against this case.
Okay. Are there any other questions for the applicant from the board?
I don't have any other questions.
All right. Lisa, is there any other final comments the staff wants to make? Did you say no?
I said no, I'm sorry.
Okay. Thank you. Mr. Murray, final comments?
No, I appreciate the board's time. Thank you.
All right. Thank you. Then we'll go ahead and close this hearing. Begin our deliberations. Mr. Welch, we'll start with you this time.
My position is pretty much the same on, as the previous one. Again, I know the intent is good, but I just don't agree with just placing the house on this type of property.
All right. Thank you. Understood. Mr. Brown.
Yep, I'd say the same thing. My position is the same as the previous case. I'm still in favor of moving forward with this variance.
Okay. Mr. Floyd.
Same as everyone else. I have the same position on this as the other. I would approve for the same reasons and incorporate my prior comments.
Okay. Mrs. Dryden.
We've approved the other setback and it was shorter than this one. And it is it seems like the best use of the property. So I would vote to approve.
All right. I have the same opinion on this property as I had on the previous property. So is there a motion and then to approve or to deny this variance? And as I said earlier, this would be, if we make a motion to approve, it would be a approval for a 13-foot reduction of the required 20-foot setback to allow for a 7-foot setback.
Make a motion to approve this variance at a 13-foot with a 7-foot setback.
Okay, thank you. Is there a second?
Floyd, I second.
So we have a motion by Mrs. Dryden to approve a 13-foot reduction to the required 20-foot setback in order to construct a new house on this property. A second by Mr. Floyd. We'll take a roll call vote. Mrs. Dryden.
Yes.
Mr. Floyd.
Yes.
Mr. Brown.
Yes.
Mr. Welch.
No.
Sanderson, yes. So it's approved 4-1. All right, let's look at the findings of fact and conclusions of law. Mr.
Chair?
Powers.
Okay.
Yes, sir. So I would just offer these edits for the board's consideration. And number 1, we would add comma LLC to the end of the sentence. And number 14, you would delete the word not. So it would say the hardship does result. And number 15, you would change it from 15-foot variance to 13-foot variance. 16, you would also delete the word not. Number 17, you would then change it from 5-foot setback to 7-foot setback. Number 19, you will also delete the word not. And then in conclusions of law, number 1, you would delete not. Number 2, you also delete not. Number 3, you would add the word not. And number 4, you would delete the word not again. With that, that would be my recommendations for any amendments to ensure conformity to your actual last vote to approve. And I am open to any other thoughts or suggestions for amendments.
Thank you, Mr. Powers. Are there any other changes or revisions that the board wishes to make? Hearing none, is there a motion?
I make a motion to approve the finding of facts and conclusions as amended.
Second.
We have a motion by Mrs. Dryden, a second by Mr. Brown to approve the findings of fact and conclusions of law as amended. Take a roll call vote. Mrs. Dryden.
Yes.
Mr. Brown.
Brown, yes.
Mr. Welch.
Welch, yes.
Mr. Floyd.
Floyd, yes.
Anderson, yes. So those are approved. I guess we need to revisit case 2020-092, findings of fact and conclusions of law. Mr. Powers?
Yes, sir. I would ask for someone to make a motion to amend your previous vote just to account for the following. Again, number 1 would add comma LLC to the end. Number 14 would delete the word not. Number 15 would modify it from 15-foot to 14-foot variance. Number 17 would then change it to a 6-foot setback instead of a 5-foot setback. Number 19 would delete the word not. And then again, we've already addressed the conclusions of law previously with the vote. If a motion to amend were so moved, that would account for all of that and allow the vote to stand as previously approved.
Okay, this is Dryden. I make an amendment to approve the finding of facts and conclusions as amended by Mr. Powers.
Thank you, Mr. Dryden. Is there a second?
Sorry, I was on mute. This is Brown. Second it.
All right, so we have a motion by Mrs. Dryden, a second by Mr. Brown to approve the amended findings of fact and conclusions of law as stated by Mr. Powers for case number 2020-092. We'll take a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Brown,
Brown, yes.
Mr. Welch,
Welch, yes.
Mr. Floyd,
Floyd, yes.
Sanderson, yes. Okay, we have 2 more pieces of business to take care of, and then we'll be done. We need to approve the meeting minutes from the August meeting and the September meeting. Were there any comments or revisions, or is there a motion to approve those meeting minutes?
This is Brown. Motion to approve the August and September meeting minutes.
Thank you.
This is Ms. Dryden. I second that.
Okay, we have a motion by Mr. Brown, a second by Mrs. Dryden to approve the August regular meeting minutes and the September regular meeting minutes. We'll take a roll call vote. Mr. Brown,
Brown, yes.
Mrs. Dryden,
Yes.
Mr. Welch,
Welch, yes.
Mr. Floyd,
Floyd, yes.
Sanderson, yes. So those were approved. And then the last item, Lisa or Shad or Max, our next meeting is scheduled to be November 24th, the Tuesday before Thanksgiving, and then we're scheduled to have the December meeting 2 weeks later. I think it's December 8th. Is there a reason why we could not combine those meetings into just the December 8th meeting? The reason I'm asking is I'm having to have a surgery done on the 19th, so it'd be the Thursday before. So I would still be able to participate, I believe, in the meeting. I could do it remotely, obviously, but if there's not enough cases on the November docket and or the December docket, I don't know how many. That's why I'm asking about the caseload to see if there's a way to merge those two or if we need to have separate meetings 2 weeks apart.
There would be 4 variances and 2 appeals on a November meeting if it were to be held.
And we have any idea about December yet?
We don't.
Okay. Would there be, I guess, for the board members, or the board be able to have a quorum there? Mr. Brown, would you be present in the event that I would need you to run the meeting for me?
I should be able to, yes.
Okay, does the board want to just continue with the schedule as is with the November meeting and then the December meeting 2 weeks later?
I would really like to not have the November, that Tuesday before Thanksgiving. My family travels, and I know we're in the pandemic, but we will still be gathering outside of Charlotte. And it would help me because I don't know that I can be present for the November meeting.
Thank you. That's why I was asking the question. So it may just mean a longer December meeting if we merge the two.
But December the 8th would be, I would prefer that myself.
Yeah, I think that's the date. Is that correct, Lisa?
Yes, that's correct.
Okay. Any other thoughts from the board?
Lisa, would it be an undue hardship for the people that have requests for variances if we delayed it 2 weeks?
I don't have the list in front of me. It might delay some timing for some people.
Chad, historically, haven't we merged when we could? We've combined these two meetings, isn't that correct?
We have.
Yeah, I think the entire time I've been on the board, we've always merged those last two meetings.
Yeah. So is there any more thoughts from the board? We don't need to have a motion for that, right, Thomas? We can just, or how do we need to do this if we're going to combine the two, Thomas?
You would actually would not necessarily be combining. You would just take a vote to eliminate the November meeting from your actual calendar, your published calendar, and then Shad and his staff will notify the clerk's office to remove that one from the agenda.
Okay. And do we need to make a motion and approve that, or?
Yes, sir, because that's already part of your published calendar for the year. So this motion would be necessary for Shad to then notify the clerk's office about the change.
Okay. Any other thoughts from the board? Is there a motion from the board, or we want to keep it the same?
This is Dryden. I make a motion to eliminate the November meeting from our calendar and meet on December the 8th.
Thank you. We have a motion on the floor. Is there a second?
I just have a question before I second it. Do we need to say, just in terms of the language, should we say we're eliminating the meeting, or are we merging the meeting with the December 8th meeting? Does it make a practical matter, Thomas?
It does not. It does not, sir.
All right.
Staff will take care of that administratively on the back end. Your meeting schedule is your meeting schedule. When an application will be heard is based on whenever your meeting is actually available.
Okay. All right. Well, I second that motion then.
All right, we have a motion to, I guess, cancel our November meeting and delete it from our schedule. We have a second by a motion by Mrs. Dryden, a second by Mr. Brown. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Brown,
Brown, yes.
Mr. Welch,
Well, yes.
Mr. Floyd,
Floyd, yes.
Sanderson, yes, that's approved. So with, as far as I know, Lisa or Thomas, is there any other business that the board needs to take care of at this time?
I am unaware of anything in addition that the board has to take care of. I'm going to look to Lisa and Shad to confirm or deny whether there are additional items on the agenda.
There are no additional items on the agenda.
All right, with that, then I'll adjourn the meeting. I hope everybody has a healthy and safe Thanksgiving, and we'll reconvene on December 8th. And please stay well.
Thank you. Stay safe, everyone.
All right,
Good luck
thank
with
you.
your surgery.
Bye.
Bye-bye.